Just to introduce myself, I'm Eric Phillips, Georgian Law, 34 years with Georgian, and I specialize in consumer and commercial credit, okay? So we were able to design a program that judicially, nice big word for going to court, getting a court order to remove short sale or foreclosure information from a borrower's credit reports. So this is my favorite kind of couple of questions to ask. How many of you are doing short sales? Yeah, fine, okay. How many of you subscribe to the philosophy that a short sale affects you for 2 years and that a foreclosure affects you for 7 years? Do you all know what I'm referring to? Okay. How many of you know how to read a credit report in this room?
Yeah.
Okay. How many of you that are doing short sales have ever seen a short sale credit rating? There is no such thing. There is no such thing as a short sale credit rating. So the 2-year and 7-year distinctions that we're all being fed are Fannie Mae, Freddie Mac underwriting guidelines. The bottom line is, from the credit reporting standpoint, if it's anything less than pages agreed on the credit report, it's considered a foreclosure or a defaulted loan. 150-point drop on your credit, 7 years from the date of last activity before it comes off. Knocks everybody out of the market. How do we do this and how does this work? I'm going to take you through it kind of quickly today because I have to be in court later this afternoon, and I would rather be here and answer your questions. I'm going to explain the process, and we're going to go to Q&A afterwards. RESPA 6 states that the information being reported on the mortgage has to be reported accurately. We pull a copy of the credit report, we subpoena the original loan documents, we analyze the information as it's being reported, and we identify the inaccuracies. Typically, the inaccuracies appear in 2 areas. The balance, if you have a client that has a neg-am loan that started at $300,000, now it's at $341,000. So we find inaccuracies in the posting information and in the balance. We go back to the bank and we formally request of the bank to change the information. We request it twice. The bank ignores that. It ignores those requests. At the end of the second request, which is about 65 days, we file a small claims action. And if you go in this little pamphlet that we have, and you go to the, I believe it's 3rd page, and it'll say court order, and you'll see the judgment, okay? Our client is the plaintiff, the bank is the defendant. Does everybody have the judgment in front of them?
Can I have one? Can I have one, please? That's it? No.
I can copy. Can I copy more?
Can you maybe snuggle up with that, ladies and gentlemen, and you have an extra? Here you go.
Thank you.
Okay, there we go. Okay. So our client is a plaintiff, bank is a defendant. Our first cause of action, if you look at item 1 that is in the box, we sue for $1. Okay, it's pretty cool. The reason why, there's 2 reasons why we do this. What we tell our clients is the reason why we sue for $1 is because we know the bank doesn't have a financial interest in this case and they're not going to fight it. Okay. Additionally, we know that when we go to small claims court, the judges are what's called the judge pro tem. They're other attorneys typically, and there is no way that they can assess damages. So as other attorneys have tried to duplicate this process, they go to small claims court, they request the maximum $5,000, $7,500. All those cases are automatically rejected because the judge pro tem cannot figure out and calculate the damages. So we're way ahead of this game. We understand that, so we just sue for $1. Our second cause of action is, if you come down to number 9, and you see it circled, I don't have my glasses, but it should say something like remove all negative information from countrywide loan number, whatever it is. Does everybody see that box? Okay. So as we're presenting before the judge, and the other side appears and says, but your client had a foreclosure, your client had a short sale, the issue isn't whether the client had a short sale or a foreclosure. The true issue is that the information is being reported inaccurately, and the federal law requires that the information be reported accurately. It's very simple. It's called a non-defensible position. We have close to 500 cases in the last 13 months, I've got to not quit, and we have yet to lose one. Okay? Very, very strong with this. Okay? We get this judgment in hand. You'll see a judge's signature at the bottom. We now have this piece of paper. This is not a dispute form that goes to a credit bureau. This is not a letter from a bank. This is a judge's order. What do we do with this once we have this in hand? We submit to 6 databases: TransUnion, Experian, Equifax. Everybody's familiar with those 3. There are 3 additional: MERS, LoanSafe, CoreLogic. This judge's order gets submitted to all databases, and it permanently, by court order, removes the information from the database. Everybody with me so far? Okay. So So the bottom line of all of this is this whole exercise that we do, the steps that are involved, the identifying the inaccuracies, so on and so forth, is all to get to this judgment. We receive the judgment, submit it to the database, wipes it out from everywhere, and it enables that short seller or that foreclosure person to come back into today's market and repurchase and remortgage at today's rates. Pretty good, right? Everybody with me so far? Very simple stuff. Okay. Pricing, what do we charge? Well, this was kind of the difficult part. We were all over the board until about 6 or 7 months ago about how to price this. We've had other attorney firms come to us and say, well, you're going to ruin the market for other attorneys. You should charge $7,000 to $10,000. I have a problem with that because I don't want it to smack of the loan mod market, okay?